mission statement. The Oversight Committee mission statement. We exist to secure two fundamental principles. First, Americans have a right to know that the money Washington takes from them is well spent. And second, Americans deserve an efficient, effective government that works for them. Our duty on the Oversight and Government Reform Committee is to protect these rights. Our solemn responsibility is to hold government accountable to taxpayers, because taxpayers have a right to know what they get from their government. We will work tirelessly in partnership with citizen watchdogs to deliver the facts to the American people and bring genuine reform to the Federal bureaucracy. This is the mission of the Oversight and Government Reform Committee. I will now recognize myself for 5 minutes for the purposes of an opening statement. Approximately 3 years into our economic recovery, America's labor and capital markets continue to face unprecedented challenges. The U.S. unemployment rate has now been above 8% for 40 consecutive months, and nearly 24 million Americans are either out of work or underemployed, despite various government-driven initiatives. To make matters worse, outdated and even oftentimes new government regulations continue to limit the ability of small businesses to access capital, which is the lifeblood of our economy. Repairing and strengthening our markets will not occur overnight, nor will it be accomplished by more government regulation. In an effort to address these challenges, the focus of today's oversight hearing is on a bipartisan bill signed into law this past April, meant to promote capital formation for small businesses by relaxing various securities laws. Titled the Jumpstart Our Business Startups Act, is commonly referred to as the JOBS Act. Let me first say that the JOBS Act is a significant victory for capital formation and entrepreneurship here in the United States. I'm particularly proud that the efforts by this committee, initiated by Chairman Darrell Issa back in March of 2011, his letter to the Securities and Exchange Commission Chairwoman, Mary Shapiro, helped develop the JOBS Act and modernize our securities laws. For instance, elimination on the ban on general solicitation, a rule that has been in place since the Securities Act of 1933, will improve the ability of small private businesses to communicate with investors and raise capital. Increasing the private shareholder cap from 500 to 2,000 that a company may have before registering with the SEC has been welcomed as a logical adjustment. It simply reduces the number of instances a company is forced to endure a complicated SEC filing process merely because it attracted too many accredited or institutional investors. Now, Title III of the JOBS Act, based off legislation that I authored, creates a new Federal securities exemption to permit equity-based crowdfunding. After introducing the first crowdfunding bill in Congress, I reached out to my colleagues on the other side of the aisle to build a bipartisan coalition so that we could actually enact this bill to address these concerns of the interested parties. Specifically, I want to commend Congresswoman Carolyn Maloney, who serves on this subcommittee, as well as the Oversight and Government Reform Committee at large, and also serves with me on the Financial Services Committee. Now, Carolyn and I don't often see eye to eye on matters of public policy, but in this instance, we collaborated and worked together to take the legislation I introduced to improve it. Now, Carolyn had a number of concerns about fraud and a number of investor protection ideas, and we worked very diligently to craft a very balanced bill that we were able to pass, not just out of committee, but on the House floor. And before it came to a vote on the House floor, President Obama put forward a statement of administrative policy that he endorsed and would sign the bill. Well, unfortunately, due to a few senators who, I think, misinterpreted the spirit and promise of crowdfunding, the Senate inserted imperfect, we'll just call them imperfect, provisions that jeopardize the vitality of equity-based crowdfunding and complicated SEC rulemaking. As the SEC considers comments regarding crowdfunding the crowdfunding title of the Jobs Act, it's clear that the Senate's 11th hour changes have unnecessarily made sections of the Jobs Act ambiguous and inconsistent. Today's hearing serves as an opportunity for Congress to hear from knowledgeable folks that either participate in the arena of crowdfunding as it now exists. It's not equity-based. It's not on the investor side, but crowdfunding as it now exists, market participants and academic experts about these provisions of the Jobs Act, and I want to get their thoughts, and that's really what this is about. Our intention is for Congress, interested parties, and the SEC to work together to ensure that effective rules and policies are promulgated that will allow crowdfunding to flourish. And if crowdfunding flourishes, I think our small businesses have another opportunity to flourish. I thank the witnesses for making the trip here, and I want to thank the ranking member, Mr. Quigley, for his involvement on this area of public policy as well as many others. And with that, I recognize the ranking member for 5 minutes.
Thank you, Mr. Chairman. I want to thank the Chairman for holding this hearing to examine the implementation of the Jobs Act. The Jobs Act, as you know, was passed with bipartisan support and signed into law by the President on April 5th of this year. The Act alters Federal securities laws and regulations to make it easier for small businesses and startups to raise capital. For example, the Act will create a unique status for emerging growth companies that will allow these companies greater flexibility in testing the IPO waters. The Act will also lift restrictions on the ability of these startup companies to raise capital. Startups, if they survive their earliest years, make an outsized contribution to sustainable job growth. Under Title III of the Jobs Act, startups will now be able to raise capital they need through crowdfunding. This is a welcome step forward, and I commend the President who endorsed the idea in his 2012 State of the Union address and the Chairman of the Subcommittee who sponsored the original crowdfunding legislation for working together on this issue. At the same time, the regulatory restrictions that were rolled back by the Jobs Act were originally put in place for a reason. There are legitimate concerns that exempting this type of activity from securities regulation would open or expand opportunities for fraud. Just as clean water standards keep our water safe to drink, financial regulations protect us against unsafe financial products. While Congress judged correctly, in my view, that there were too many hurdles to raising capital, the SEC's mission is still to protect investors and maintain fair, orderly, and efficient markets. New rulemaking under the Jobs Act should follow the same process and procedures as in the past. There is no reason the Jobs Act should be prioritized in front of pending Dodd-Frank rulemakings, which have been delayed as a result of intense scrutiny from Congress and the courts. The same standards should apply equally to all the SEC's rulemaking that are required by law. I also believe that Dodd-Frank and the Jobs Act are two sides of the same coin. Before and during the financial crisis, our financial regulations were deficient. As banks collapsed and the housing market bottomed out, investors lost their savings, homeowners lost their homes, and millions of Americans lost their jobs. By passing and implementing Dodd-Frank, we will ensure that the next generation of Americans is not so vulnerable to financial catastrophe. At the same time, we can also recognize that not all regulations are necessary and that some may inhibit job growth more than protect it. That is why I was proud to support the Jobs Act. Going forward, I am eager to work with the SEC in both sides of the aisle to ensure that these two acts of Congress are implemented in a timely and responsible fashion. Thank you, Mr. Chairman, and I yield back.
I thank the ranking member. Members will have 7 days to submit opening statements for the record. We will now recognize our panel. Mr. Brian Cartwright is a scholar, the scholar in residence at the Marshall School of Business, University of Southern California, a senior advisor at Potomac Global Partners, and former general counsel of the Securities and Exchange Commission. Thank you for being here. Mr. Alon Halil-Tuk, did I say that correctly, sir? Thank you. Is the co-founder and chief financial officer of Rocket Hub Incorporated. And for those of you who are not familiar, it's a fantastic crowdfunding site. doing exciting things. And Mr. C. Stephen Bradford is a professor of law at the University of Nebraska College of Law and has written numerous works on crowdfunding. Mr. John Coffey, Jr. is a professor of law at Columbia University Law School. It is the policy of this committee that all witnesses be sworn in before they testify. So if you'll please stand and raise your right hand, actually. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? All right. Thanks. You may be seated. Let the record reflect that the witnesses answered in the affirmative. In order to allow time for discussion, we have the lights set up for you. We're members of Congress, so they're very simple. Right? Red means stop. Yellow means hurry up and finish. Green means go. So we'll give you 5 minutes to summarize your opening statements. Your opening statements, your written statements will be as a part of the record. And so we'll begin. Mr. Cartwright, you're recognized for 5 minutes.
Well, Chairman McHenry, Ranking Member Quigley, members of the subcommittee, you've honored me with your invitation to appear before you today, and I thank you for having me. You have my written testimony, and I won't try to rehearse that testimony again here in these brief introductory remarks. Instead, I want to frame the questions and discussions to follow by offering my perspective on why the Jobs Act was passed with the support of the administration by overwhelming votes in both houses of Congress, and why I think we're here today. I believe the Jobs Act was passed because there's a widespread, fully bipartisan understanding that something has gone quite wrong in the world of American public companies, particularly the newer up-and-coming companies. After all, the number of public companies, exchange-listed companies, has declined dramatically. In the roughest of numbers, we've gone from having somewhere around 8,000 exchange-listed companies to something in the vicinity of 5,000. That's a dramatic drop. It's happened because not enough companies are signing up to go public to replace those who drop out. The number of initial public offerings has trended down far below previous levels. But the most alarming development of all may be this, and I know this from my days in practice. Back in the day, venture capitalists would take a successful, innovative new company public. And many of those companies would then blossom and grow and produce countless jobs, and we know that most of the jobs actually come after a company goes public. And that's what used to happen, upwards of 80% of the time. But today, that number has flipped. Today, over 80%, approaching 90%, of successful venture-backed companies are acquired rather than taken public. And that makes all the difference in the world. Because we know that acquisitions, rather than growing jobs, often subtract jobs, because the acquirer seeks to achieve efficiencies, as the press release will euphemistically refer to it. So I ask you to just imagine what the world would be like today if Microsoft had been managed to make it as attractive as possible to its most likely potential acquirer, IBM, and IBM had, in fact, then acquired it. And I submit to you that if that had happened, Seattle would be a very different city today. And replicate that hundreds of times over, and the U.S. would be a very different country today. Public companies that were originally venture-backed are estimated by some to contribute something like 20% of our current GDP. Imagine the problems we'd be facing if we didn't have that 20% today. I think those are illustrative of the developments that I believe led to the Jobs Act, which, in my view, makes only quite modest incremental tweaks to the existing system. Time will tell, but those modest incremental tweaks may well prove insufficient to get us where we need to be, and maybe some of the questions you'll be asking will be directed that way. But the Jobs Act is a welcome, broadly bipartisan attempt to move us in the right direction. And of course, even those modest steps have been resisted by the defenders of the status quo. So the SEC needs to be encouraged to move with all deliberate speed to implement the Jobs Act promptly and faithfully. And I thank you very much, and I eagerly look forward to your questions on this important topic.
Mr. Halil Tuck.
So, Mr. Chairman McHenry, Ranking Member Quigley, and members of the committee are able to attend. My name is Alon Halil Tuck. I'm a co-founder and CFO of Rocket Hub, and I thank you guys for the opportunity to provide testimony on the implementation of the Jobs Act and the proper elimination of government barriers to small business capital formation. Background on Rocket Hub. Rocket Hub is an established crowdfunding website, one of the largest in the world, and we provided a platform for the launch of over 8,000 campaigns so far since 2010 and raised over $2 million to support entrepreneurs and small businesses. These successful campaigns have provided funding to businesses of all types, from a local bakery to a startup developer of medical devices to enabling the financing of a film production. Crowdfunding really is the application of new technology to an old idea. People have always sought support in their community to help raise money for new business. The advent of web-based social networking allows people to expand their community to their online friends and to benefit from the lower cost of a web-based platform. Thanks to Title III of the Jobs Act, crowdfunding in the U.S. will soon expand to permit the sale of stock by these entrepreneurs to their supporters. And we at Rocket Hub look forward to this development, and we intend to register as a crowdfunding portal as provided in the Jobs Act. While I believe that the Jobs Act will benefit small businesses in the U.S., I also believe that its impact can be improved for the proper use of the Securities and Exchange Commission's discretion in rulemaking, and for certain amendments to the Act as well. I see 3 areas for improvement. I'm going to try to fit it into the time I have. In the Jobs Act, Congress provided that issuers utilizing crowdfunding platforms must provide investors with certain information, including audited financial statements where the issuer seeks to raise more than $500,000, or such other amount as the Commission may establish. I believe that this $500,000 threshold is too low, and that the audited financial statement should not be required unless the issuer seeks to raise $1 million. Crowdfunding typically attracts startup companies and small businesses, and audited historical financial statements of these type of companies may have little or no operations or relevance. They do not provide investors with more meaningful information as compared to unaudited financial statements. Yet they impose a significant cost on the entrepreneur, which might really kill this. Making this change could save small businesses tens of thousands of dollars for opening up the opportunity for them to take full advantage of the platform. A second area where the Commission should exercise its discretion in rulemaking is really by minimizing upfront expenses to the entrepreneurs and small businesses that seek to crowdfund. Crowdfunding platforms usually charge fees for successful projects. This allows small businesses to access crowdfunding at a minimal initial cost, which is critical. If they attract support for their project, then they have the funds to pay fees. If their idea does not attract support, their costs are minimal, no support is charged, and the entrepreneur can come back in the future with a new idea. In implementing the Jobs Act, it's important that the Commission considers and is careful around preserving this fee structure. Platforms should be able to charge fees on successful projects while not imposing costs on projects that do not attract funding. This structure will allow more small companies to use crowdfunding while reducing their risk if they're unable to attract financing. One area that Congress should address the Jobs Act is to raise the crowdfunding exemption to $5 million from $1 million. The higher amount will allow more small businesses who need capital to utilize cost-effective crowdfunding method. Currently, a company that seeks more than $1 million is unable to use crowdfunding and must still rely on traditional venture capital, angel investors, credit card debt, or small business loans. These sources may not be available to all businesses, especially startups, women and minority-led businesses, and those traditional small businesses that fall outside of the high-tech model. Raising this limit will allow crowdfunding to more effectively compete as a source of funds with venture capital and banks, and giving small businesses more options to drive down financing costs. Crowdfunding could be an important economic tool to help small businesses grow and drive job creation. And I believe that raising the aggregate limit for crowdfunding to $5 million, limiting the costs associated with audited financials to raises above $1 million, and aligning the interests of companies, investors, and platforms with a success fee structure, we can increase the economic benefit provided by crowdfunding. These reforms will increase the number and types of companies that choose to raise capital and expand the role of crowdfunding in small business finance. We also expand the opportunity and benefits to crowdfunding investors, allowing these small investors the ability to participate in the growth and success of a wider range of companies, including those in their communities. So I'm going to quickly close with a quick response to two common questions. First is, will crowdfunding lead to a lot of fraud by issuers? No, it won't. In fact, crowdfunding structures help minimize risk. Crowdfunding is highly transparent, and there's substantial feedback from community participants. The crowd helps police players and keeps them honest, and crowdfunding portals and regulators are able to drive standardized and understandable terms across offerings. I thank you for your time, and I'm looking forward to questions.
Thank you. Thank you so much. Professor Bradford.
Chairman McHenry, Ranking Member Quigley, members of the subcommittee, good afternoon. My name is Steve Bradford. I'm a professor of law at the University of Nebraska. Much of my work focuses on small business capital formation under federal securities law, and it's an honor to be able to address you on that subject today. I've recently written 2 articles on crowdfunding, and I would like to focus my comments on the crowdfunding provisions of the Jobs Act. I believe that crowdfunding could spark a revolution in small business financing, opening up much-needed new sources of startup capital. But whether that happens depends in good part on the regulatory burden. Those small offerings will be possible only if the cost of complying with securities regulation doesn't consume a large portion of the offering proceeds. The new federal securities law crowdfunding exemption created by the Jobs Act is an important first step, but that exemption isn't complete until the SEC enacts implementing regulations. The usefulness of the crowdfunding exemption will depend in part on how the Commission exercises its rather substantial regulatory authority. My written statement includes a number of specific recommendations concerning the crowdfunding rules, and I'd be happy to discuss any of those with the members of the committee. But in the time available, I want to limit myself to 4 important points. First, cost is a critical consideration for the very small offerings that crowdfunding facilitates. Because of that, I believe the SEC crowdfunding regulation should be as light-handed and unobtrusive as possible. In the name of investor protection, the statute already imposes significant regulatory requirements on both crowdfunding issuers and on the brokers and funding portals who will act as intermediaries in crowdfunded offerings. Adding additional layers of regulation on top of those requirements would increase the cost of using the exemption without much additional benefit, and would also be inconsistent with the thrust of the Jobs Act to reduce the regulatory burden on small business capital formation. Second, to the extent that any additional regulation is required, it should be imposed on crowdfunding intermediaries, brokers and funding portals, rather than on the entrepreneurs raising funds. Crowdfunding intermediaries will be more sophisticated and more heavily capitalized than the small business issuers engaging in crowdfunding. Those brokers and funding portals can afford Securities Counsel to guide them through the regulations. They will also be repeat players, so they can spread any regulatory costs over a large number of offerings. Because of that, I think it makes sense to center the regulation on those intermediaries rather than on the companies raising money. Third, the SEC crowdfunding regulation should be clear, concise, and written in plain English. The SEC requires corporate disclosures to meet those requirements in order to facilitate understanding by investors. In drafting the crowdfunding rules, the Commission should follow its own plain English standard in order to facilitate understanding and compliance by crowdfunding issuers. Many of the small business issuers using the crowdfunding exemption will be legally and financially unsophisticated. If the regulations are dense and legally complex, those businesses will need sophisticated Securities Counsel to guide them through the regulations. That would significantly increase the cost of the offering, and for these small offerings, cost is all important. That leaves issuers with 2 alternatives. Either they try to navigate the complex rules on their own, in which case violations are likely, or they would simply not use the exemption, in which case the promise of crowdfunding won't be realized. The best way to deal with the issue is to write the rules so that small business entrepreneurs can understand them without hiring expensive attorneys. Fourth and finally, the SEC should adopt a substantial compliance rule to protect issuers and crowdfunding intermediaries who inadvertently violate some of the requirements of the exemption. The exemption contains a lot of detail, and as I've said, the issuers using it will not be particularly sophisticated. Because of that, the possibility of an inadvertent violation is high, and the consequences of even a minor, immaterial technical violation are drastic: loss of the exemption, violation of the Securities Act, and liability to return all of the money to every single purchaser. Other Securities Act exemptions protect issuers who substantially comply with the requirements of the exemption or who reasonably believe the requirements of the exemption are met, even if it turns out they aren't. And the SEC should include similar rules in the crowdfunding regulation. My written statement includes a number of other specific recommendations, but my time is just about up, so let me just thank you again for the opportunity to talk to you today.
I certainly appreciate it, and we'll now recognize Mr. Coffey.
Thank you, Chairman McHenry, Ranking Member Quigley, members of the subcommittee. My name is Jack Coffey, and I have been working in the field of securities regulation and initial public offerings for over 40 years. Let me make 3 basic points, all briefly. First, I believe the greatest enemy of job creation today is not overregulation, but the loss of investor confidence. Today, American investors have lost confidence in the IPO marketplace. This is evidenced by the Facebook fiasco, the drying up of the IPO pipeline, and the low trading price of most of the recent social media initial public offerings, all of which are trading below their offering price. This erosion in confidence probably goes all the way back to the burst of the Internet bubble in 2001, and confidence has not been restored. But more recently, there's been a new focus. Investors are again and again complaining about the prevalence of selective disclosure in IPOs, as issuers, underwriters, and analysts seem to be tipping, as seems to have occurred in Facebook, projections and forecasts to preferred institutional investors. I think there are a number of problems with the IPO marketplace today, and I agree with many of the comments made by Oversight Committee Chairman Issa in his recent letter to the SEC, particularly his views that there should be greater attention given to the role of auctions in this process. But in an oversight, in overviewing the IPO process, I would point you particularly to the problem of selective disclosure. There is no efficiency in selective disclosure. This is an issue of fairness, and I think there are ways in which the Jobs Act actually compounds this problem, as I set forth in my written testimony. Let me move now to my second point. The Jobs Act, on virtually every page, requires the SEC to adopt new rules to implement the Jobs Act, and it imposes fairly tight timetables, and the first of those deadlines expires on July 4th with respect to crowdfunding. Under recent decisions of the D.C. Circuit Court of Appeals, these proposed rules that the SEC must adopt shortly are vulnerable to judicial second-guessing. Either the D.C. Circuit might find some cost to be overstated, or it might find some benefit to be understated, or it might even say that the empirical studies done by others that the SEC is relying upon are just not reliable. All this has happened repeatedly in recent decisions. As a result, the SEC stands at risk that its rules could be found to be arbitrary and capricious, as has happened on 3 or 4 recent occasions. As a result, virtually everyone affected by SEC rules today under the Jobs Act has an incentive to sue. If they're not happy, they're going to find an attorney, and many are going to go to court. This will result in continuing uncertainty, confusion, and delay in the implementation process. Even if the SEC makes a superhuman effort, litigation is still predictable because someone who is not happy with the rule now has a fair option of going to court and suing. Third point, which relates to the second. I reviewed the Commission's most recent policy statements, including the statement dated March 16, 2012, setting forth its, quote, current guidelines on economic analysis and SEC rulemaking. I believe these new guidelines properly integrate economic analysis with the rulemaking process. They do require the Commission to consider economically reasonable alternatives to the rule being proposed, and they do require the careful matching of costs and benefits. Of course, I cannot tell you that the Commission will always follow these principles in rules that have not yet been proposed or formulated, but I can tell you that whatever the Commission does, whatever heroic effort it may make, there is still a real prospect that the D.C. Circuit could disagree and substitute its judgment for the Commission's judgment. If that happens, I cannot tell you that a Federal court has a better judgment or greater expertise than the Securities and Exchange Commission. It is not more expert. It is not more sensitive to the market. Thus, I do not think we will come out with better rules through that process. My bottom line here is that the SEC is today caught between the rock and the hard place. It has been asked to expedite rules, and it is trying to do so, but it faces a somewhat unsympathetic bench that is quite skeptical of rulemaking in general. I could give you some specific examples and might like to do so if we have questions. For example, the SEC has to adopt rules both on the use of audited financial statements, on the use of follow-up periodic disclosure after an offering. This is true both under Sections 3B and under the new crowdfunding exemption. I think in all those areas the Commission is doing what Congress has told it to do, but I think we're going to see a long battle because I predict that those unhappy with these rules are going to try to exercise the judicial option. Ultimately, the danger here is that we could be led back to the Lochner era of the 1930s, when courts could substitute their analysis and their preferences for those of the agency by saying that it interfered with freedom of contract. Today, instead, they'll be saying it interferes with proper cost-benefit analysis. There's a danger that looms here, and I'll stop at that point.
Well, I thank the panel for their testimony, and your written testimony will be in the record. I'll now recognize myself for 5 minutes. Now, securities regulation, we have a foundation of 1933 and 1934 for the essence of our securities regulations. That's still the foundation of what we deal with today. And at the time, Congress was acting to deal with a challenge, which was the folks standing on street corners hawking securities. Right? Times have changed. We now have the Internet. What we have found, and what I've said multiple times before, is that under the mentality of the SEC, the website eBay would not be able to exist because the SEC would not be there to root out folks that have lower net worths from purchasing products. Instead, we know that eBay sells billions of dollars on a yearly basis between people that don't know each other, two individuals of average means that don't know each other. But under the SEC mentality, that simply would not be able to take place without massive fraud. But then we have the SEC, and we've known the very large failures of the SEC to root out fraud among regulated entities that they oversee, and that is unfortunate. We don't want that. We don't want any fraud in this, in the crowdfunding space or in securities at all. So there's a question of how we root this out. Mr. Halil-Tuck, you mentioned that you believe that fraud could be, in essence, rooted out through the power of the crowds. Can you explain why you believe that?
Yeah, absolutely, not a problem. Crowdfunding is very transparent. As I mentioned earlier, there is a lot of feedback from community participants. In essence, the crowd basically polices players. It keeps them honest. The beauty about crowdfunding is you have a centralized location, which is the portal, and it allows for communication by potential investors to analyze and share their views on offerings. And the web-based structure also allows portals and regulators to provide risk disclosure and investor education. We definitely expect portals and their operators to undertake a gatekeeping role in authenticating issuer identity and requiring minimum standards. But what we've noticed historically, both on our platform and others, is the crowd is extremely wise in assessing potential risk. On top of that, looking at 1930, for example, you didn't have the access to information you have now. I'm able to go onto Google, for example, and research a company to see their track history, see their online presence as well as offline. I'm able to pull up a credit score. I'm able to research an individual all from the comfort of my home. It's just something that every investor is able to do now that simply did not exist before computers, before the Internet. The access to information to the individual now is at a level that's unheard of. We're just not utilizing it for fraud prevention, which is very unfortunate.
So fraud prevention, Professor Bradford, you mentioned in your writings, you mentioned also in your testimony today, that imposing additional layers of mandatory disclosure on issuer rather than the portal is not the best way to root out fraud. Can you flesh that out for us?
Well, it's mostly because the entrepreneurs that are going to be using this, and these are relatively small offerings, relatively inexperienced entrepreneurs, simply can't bear the cost of that burden. If I'm making a $200,000 offering, it doesn't take much cost before I simply can't do it. Every dollar that's paid for regulatory costs, every dollar that's paid to the intermediaries is a dollar that I don't get to use for my business. Therefore, it makes more sense to try and do it structurally through the entrepreneurs and protect fraud that way than imposing a whole bunch of complicated disclosure requirements that these people probably aren't going to fully understand in any event without having to hire securities counsel, which is another expense.
So do the 50 states, as it stands now, have the ability to root out fraud?
Well, the 50 states and the SEC. I mean, nobody is talking about taking away the anti-fraud rules. The states, under the Jobs Act, still have the ability to enforce their fraud restrictions. That's not preempted. The SEC has the existing anti-fraud rules plus an additional anti-fraud rule in the crowdfunding provisions. And that's the best way to attack fraud because that only imposes cost on the fraudsters. The problem with expensive mandatory disclosure requirements is you're imposing costs on everyone that wants to raise money, most of whom, at least I believe, are honest entrepreneurs and acting in good faith to raise money for their business. And everything that we impose on them in the name of fraud protection is going to be borne mostly by honest people.
Well, thank you for your testimony, and we expect a second round of questions. So I'll now recognize Mr. Quigley for 5 minutes.
Well, the same two gentlemen, just for the sake of argument, you recognize a little bit of the difference of most of the transactions that take place on eBay. That most people know when they're buying a bike on eBay what a bike should be, right? But some of these investments, Mr. Hillel-Tuck, you'd acknowledge that a little more sophistication involved here, and I supported this act, but just for the sake of argument, let's talk about how we implement it. At least some sense of protecting those because of the level of sophistication that's involved with this and the concerns that they can take place with people who aren't as practiced. You acknowledge that. They're not as practiced in investing in the first place.
That's actually a great position we can discuss. What is very critical, what a portal provides over any other kind of real structure is standardization of a lot of the requirements and the education that absolutely is necessary due to the different levels of sophistication. Granted, assuming an accredited investor is sophisticated is ludicrous in itself. That said, through a portal, what you're able to provide is, and we completely agree with Professor Bradford, it's critical to make it as seamless and low friction as possible, and cost is the decisive factor. The SEC can very easily make this cost prohibitive when that's completely unnecessary. Fraud and investor education go very much hand in hand. One of the things we've noticed with crowdfunding right now is a lot of the network comes from individuals within your neighborhood. I mean, we have an example right now of a tea shop in Shelbyville, Kentucky trying to raise funds. They did so last year, and they raised it from within their community. And that community knows that shop. The community raises funds together to help that shop succeed. And those are the kinds of businesses that are not venture backable right now, but they do have members in their community who believe in that business, want to support that business, and are right now not permitted to do so. And the education level is different. They don't have the interest of getting a short-term return on their investment. They're looking at the long-term strategy.
Professor Bradford.
I'm perfectly willing to concede that what's sold on eBay is different from securities, and that securities are, without a doubt, more sophisticated than most of the products that are sold on eBay. But I do think that what eBay has learned through their platform about preventing fraud is useful to crowdfunding. For a fraudster, if I get money, it's money. It doesn't matter whether I'm pretending to sell people securities or whether I'm pretending to sell them goods that I don't eventually deliver. And I think the experience with eBay shows a couple of things. Number one, it shows that we can use an Internet platform to sell things. We can have fraud protection techniques in place to help prevent fraud. But having said that, I'm not going so far as to say that securities crowdfunding ought to be unregulated. I think some of the things we have in the exemption, a limit on how much people can invest that you don't see when people are buying goods on eBay, some disclosure about what's going on, what the entrepreneur is going to do. Clearly, there ought to be more regulation of crowdfunding than there is of eBay. No dispute about that.
Mr. Cartwright, if you want to weigh in.
Yes, thank you. We're talking about fraud in small offerings. And I would like to start with the baseline of where we stand today. Because, and I feel very passionate about this, if you spend most of your career in a large law firm where you're too expensive to work with small offerings, you don't really see much of this. But when you go to work at the SEC, you discover that there is an alarming, shocking amount of low-level fraud. I call it security street fraud. It's guys who make up completely fraudulent press releases in pump-and-dump schemes that claim that the company has achieved a major contract with some Chinese company or a big technological breakthrough that has commercial advantage. Totally made up. I mean, this is hardcore securities fraud, hardcore wire fraud. This is hardcore criminal behavior. Or they exploit an affinity group, the members of their house of worship, or if they are of an ethnic background, recent immigrants who are trying to make their way in America and struggling. And there's way too much of it, and it's disgusting. And they're doing that under the existing law. And they're using, sometimes, most of them don't even care about the exemption from Section 5. I mean, if you're willing to blow through the most fundamental fraud provisions in the criminal law, you're not worried about whether you have an exemption from the otherwise applicable provisions of Section 5 of the Securities Act. But if they are, they're claiming 504, typically Rule 504, typically erroneously. The way to address this, and it's a problem because it's left to the SEC to address, and the SEC doesn't have the tools. And we talk about the SEC being the cop on Wall Street, but it's not a cop. That's hype. It has a civil jurisdiction. It can't do search warrants. It can't do wiretaps. It can't do stings. And most importantly, it can't go into federal court and bring a case that ends up with a conviction that puts people in jail. That's under the Department of Justice. But the U.S. Attorney's offices around the country who are responsible, they've got a lot on their plate. And this stuff is pretty small time. At the SEC, the enforcement attorneys used to refer to it dismissively as little cases. They don't get much press. But small people who are innocent are harmed. I think the way to root out fraud, as it exists under existing law and under crowdfunding or any other change in the law, is to direct resources in an efficient fashion to bring criminal cases against these people. Very frustrating for SEC enforcement lawyers. They know these guys shrug off a civil case from the SEC. It's a cost of doing business. It's a risk. They don't mind when they're taking the proceeds from an offering and spending it on sports cars and speedboats instead of what they claimed. We need something like, and maybe there's other ways to do this, but something like a national task force in justice. National, so it has the scope and scale to develop the expertise and the efficiency to root these people out. And the U.S. Attorney's offices around the country can refer those small cases for criminal prosecution. The SEC can refer those small cases. If we started putting these people in jail the way we should, they would pretty soon, there'd be a lot less of them. I think that's what we ought to do.
Thank you for your comments. And to that point, we've retained state fraud prevention and prosecution within the law as it currently exists for crowdfunding. That way you have your county prosecutors and state prosecutors that can actually go after these, quote, small fraudsters, and I appreciate you
explaining. And the state law, as you say, Mr. Chairman, the state law enforcement is critical here because they do, at least in some jurisdictions, they are prepared to handle matters that are somewhat smaller than the federal authorities will, but frankly, I think we still need more.
Absolutely. Thank you. With that, we'll now recognize the Vice Chairman of the committee, Mr. Genta of New Hampshire, for 5 minutes.
Thank you, Mr. Chairman. Thank you all for testifying today. I wanted to address my first remarks to Professor Coffey. Thank you for being here. You had mentioned in your testimony the arbitrary and capricious findings by the courts. I'm assuming you're aware of the fact that the SEC recently instituted new and stronger cost-benefit analysis policy?
If you'll put on your microphone, turn on your microphone. Thank you.
I understand that, and I was referring to their new guidelines as of March 19, 2012.
Well, I guess okay, I appreciate that. My question would be, just by the fact that there's going to be a greater effort now put into cost-benefit analysis, wouldn't that necessarily reduce the amount of risk of any arbitrary and capricious finding?
Well, I hope that we have a better understanding and we have a workable accommodation between the SEC, one of our best federal agencies, and the D.C. Circuit Court of Appeals. Only time will tell, because right now the ease with which these prior findings were overturned creates a strong litigation incentive. Someone will always feel injured by a new SEC rule, and there's a strong incentive to sue. I hope there's an understanding that's quickly reached, though.
Would you say that the SEC in the past has put a lot of effort and energy into performing legitimate and serious economic analysis?
I think that I would agree with maybe your subtext and say sometimes it's been pro forma. I think, however, the burden cannot be overstated. If you look just at the crowdfunding provision in the Jobs Act, I count 8 different sets of rules that Congress has directed the SEC to promulgate just under Section 4A. So they have a burden, and they have very short time limits. It's hard to do everything overnight.
Mr. Cartwright, can you comment on that? I happen to think that cost-benefit analysis should be performed. I think that the SEC can perform a valuable commodity here for just about everybody, but I wanted to hear your comment.
The law requires it. The SEC is required to consider efficiency, competition, and capital formation in most of its rulemaking activities, and it's been required to do that for quite some time. I think too often in the past, and I hope this is changing, too often in the past it was an afterthought. Someone decided that there ought to be a rule, the chairman, the division director, or whatever. They get a rule-writing team going, writing it. They write the rule, and then at the end of the process, in the past at least, someone would say, oh, my goodness, there's that cost-benefit analysis, the efficiency, competition, and capital formation we've got to do. It was kind of a compliance exercise, and it was done at the end. The SEC is a lawyer-dominated agency, and the expertise that's really required here is more in the economics and the economist regime. And those people were often not consulted at all, or if they were, peremptorily. So I frankly think that it's wonderful here in America that if you believe that an agency has exceeded its authority or acted arbitrarily or capriciously, you do have a chance to get into court and question the agency's exercise of its jurisdiction. That historically didn't happen at the SEC very often, but other agencies have had this experience. The EPA, almost every matter they do is litigated by one side or another, and you get better at it, I think, as an agency if you have to respond to these legal requirements. I applaud the March statement. I think it's a very good statement, and I think that it's a huge step forward. The real question is whether this is going to be implemented in a way that gets the economists and people who are asking these questions in up front, at the very beginning. So the design of the rule is shaped in part by these considerations that the law requires, rather than creating a rule and then trying to justify it, basically lawyer it, do a brief at the end to try to justify what you've done in any event.
And then quickly on a different subject matter, can you quickly describe the changes to the 500 shareholder cap in the Jobs Act and what benefits you would foresee?
You're asking me?
Yes.
Yeah, sure. As the law exists today, prior to the Jobs Act, let's say, but rather, prior to the Jobs Act, if a company had $10 million in assets, which is a very small amount for a company of any size, so almost always that test is satisfied, and 500 record holders, then it's required to basically become a company. It has a public company. It has to register with the SEC. And it is an unfortunate development that today many of the most successful entrepreneurs no longer want to have their companies go public. When I started practice, every entrepreneur, that was the holy grail. Let's see if we can go public and do it fast, and the sooner the better. Now, some of the most successful companies, the most successful business leaders try to keep their companies private as long as possible because the disadvantages and burdens of being public are too great. So the Jobs Act, in the title in question, increases the threshold to 2,000 holders, provided that no more than 500 are accredited. Unaccredited.
So did you just say that you think people are keeping their companies private for a longer period of time because of the challenges of bringing it public, correct?
Well, it's the challenges of, not in part, the challenges, there's two things. First,
I guess my question is it investor confidence or is it overregulation?
No, I think it is not a question of investor confidence. This is coming from the company side. It has two aspects to it. The first is companies that, let's say, 15 or 20 years ago were of a scale where a public offering was feasible and the burdens of being public were not so costly, those companies would go public. Today, there's a band of companies in size and scale that no longer can swallow the overhead costs of operating as a public company and maybe of becoming a public company. So they have to wait longer until they grow bigger in order to become public. But what's really surprising is that even when they've gotten big enough so they could meet the requirements, the most successful entrepreneurs today, and if you hang out in Silicon Valley, lots and lots of people will tell you this, they want to keep their companies private as long as they can because they believe even once they're big enough to go public, the burdens are greater than the benefits. And you can see that. Google, for example, was some years ago, 2004, I think, if I've got that right. They held on longer than they could have. I mean, they picked up an SEC enforcement action against themselves and their general counsel for going too long. I think some of the recent IPOs, if you just look what happened, you can see that they held out to the last possible moment. And that's one of the reasons why we have this universe. There was an economist, I don't know if you saw it, the Economist magazine, thought by many of you preeminent Financial Weekly, had on its cover story a few weeks ago, the vanishing public company. And it showed on the cover art was a sort of scruffy Paleolithic band rushing the mastodons over the cliff, and the mastodons are all ink. They're the public companies. So we got a problem here, and it has completely reversed since the early years of my career.
Thank you, Mr. Chairman, for the additional time.
Well, thank you so much, and questions have been very good, and we'll start with a second round of questions, and I will recognize myself for 5 minutes. For the whole panel, from your review of the crowdfunding provisions of the Jobs Act, do you all agree that the SEC holds a great deal of discretion over the implementation of this section?
Start with me.
You can just say briefly.
Yeah, I will be brief. I understand I can sometimes not be so brief.
No, thank you. Mr. Oltuck, we'll come back, I promise.
Clearly true.
Okay.
Yes.
Thanks.
It's that simple. I mentioned in my testimony. One example is audited financials. It's at their discretion to change it.
Okay. Professor Bradford.
Yes, although I believe that discretion goes more in the direction of adding additional regulation than it does in the direction of cutting some of the existing requirements.
I think you want to answer, and the answer would be yes, but it's largely because Congress has delegated in every provision of the Jobs Act rulemaking discretion to the SEC. The SEC can't duck this. They were told to consider rules.
Right. So the legislation we passed with over 400 votes that I authored here in the House with the help of Carolyn Maloney was a different construct. So does this discretion, Professor Bradford, place at risk the viability of crowdfunding to actually take place in the real world? Does that, even if the SEC acts counter to the bipartisan support of this provision and the idea, and even the President of the same party as the majority of the SEC commissioners?
Well, as I said, for these small offerings, cost is an extremely important consideration. The more regulation the SEC adds, the stronger that regulation, the greater the cost of number one, understanding what the requirements are, and number two, complying with that regulation. And at some point, if the statute itself hasn't already reached that point, we reach a point where the regulatory cost makes use of the crowdfunding exemption infeasible.
So what are the areas of greatest concern for you, Professor Bradford, in how the law is actually written dealing with crowdfunding? What are the number one through, what are your top level concerns? Number them and tell me the level of importance.
Are you talking about in the way the law is written or in the regulations the SEC has to add to it?
Yes.
Oh. And
I'm giving you a rare opportunity. Oftentimes before these panels you don't get a chance to answer, but I'm giving you the rare opportunity to school Congress. So,
my greatest concern is in the disclosure requirements imposed on issuers, particularly some of the accounting disclosure, audited financial statements for companies raising a relatively small amount of money, and even for really small offerings, financial statements required of all issuers, even for, say, a $10,000 offering. That, and then there are some disclosure provisions in the statute that are relatively difficult to understand. For example, issuers have to describe the risk to investors associated with possible future deals that the company might do. I'm not using the exact language. And so that requires these relatively unsophisticated entrepreneurs to think about future buyouts, mergers, IPOs, whatever, to predict what the effect of that could be on these crowdfunding investors and try to disclose it subject to a liability provision that makes them liable if they're negligent in doing so, in failing to disclose properly. And so that portion of the Crowdfunding Act is probably my primary concern. I guess my secondary concern is a general one that I sort of mentioned in my opening statement, and that is just the lack of clarity, the complexity, the need for entrepreneurs and intermediaries to understand various provisions in the Act. For example, I mentioned in my written statement the prohibition on solicitation. Solicitation, as interpreted by the SEC, is a very broad concept, and people like Mr. Hillel Tuck, did I get that right?
You did.
Okay. Need to know what exactly they may or may not do in terms of advertising their site.
So the concern I had with the Senate provision from the get-go was as simple as the origin of Congress's action, and I could say the origin of Congress's action because I filed the first bill, and the reason why I filed the first bill was because of PBR, right? And many of you have heard this story, but you had an advertising guy who he tweeted, said, let's buy a beer company. Pabst Blue Ribbon was putting themselves up for sale or they're going to close. And it was this sort of idea on a whim until he had federal agents visit him, right? And he realized he was then told that he was breaking federal securities law because he tweeted that he wanted to buy a beer company. Well, later he put up a website. So, the idea of the crowds buying their favorite beer company. I don't think these individuals were pledging money because they thought they were going to make $1 million off of it. They wanted to support the brand that they liked. So this is what I see on crowdfunding sites as they exist now, is you have an idea that you like. Could be your local coffee shop, could be your favorite cupcake. And you invest in it because you believe in the product, not because you're going to make $1 million. It's the same reason why a lady I know, her father was a fan of the Boston Celtics. He invested in the Boston Celtics so he could say he owned a piece of the team. He's an Irish immigrant, of course. He loved that, right? So it's not, it's a slightly different idea and motivation to this point. And so the disclosure piece is important, whether or not the expense of that is too great to bear for small issuances. Mr. Halil-Tuck, you talk about your current platform that you have, and that is on the charitable side. You can pre-order a product, you can get a T-shirt, you can do a number of things. What are your offerings? What's the smallest offering you've had on your site, roughly?
We've had offerings as small as $500.
And how large? What was your biggest?
They go over 100,000. It really depends on your community.
Okay. So in that range from $500, which getting financials on that would be a little, make it a little unworthwhile, right?
Ludicrous is a mild way of putting it. You know, you're asking, for example, in an offering for a new company to put up historicals on a timeline of 0. It just doesn't make sense. I mean, it's an education issue. I think what happened is, and I read your original bill, and I've seen all the changes, a lot of the changes that happened were due to educational issues, where we're trying to approach this from an old world perspective, while you're spot on in your statement is not everybody's looking for the $1 million return. It's just not what this is about. We're really democratizing access to capital in a way that just didn't exist before. And that is allowing your cupcake store, your tea shop to get financing that's not debt. They don't have to run a credit card debt. They don't have to run a mortgage, which we saw what happened with that a few years ago. And this is completely different. You're getting support from a whole other side of your community that wants to invest in you and is simply not allowed to do so right now.
Well, Mr. Cartwright, to that end, this cost of going public. At what point under current regulations does it just, under what point of money that you have to raise going public, does it simply make it not possible to go public? Is it not economical to go public? Is that?
That's an investment banking question, and I'm not.
I know, but you're a good lawyer. You're willing to venture off into areas you don't know.
No,
I'm kidding.
At least $100 million, and these days it's probably larger than that. And what's sad is so often companies that might meet that threshold don't want to go public even then.
Okay, so you're talking about a much higher threshold.
Oh, vastly higher threshold.
Different world.
A different world.
Okay.
Different world.
So the idea of having light touch regulation on the intermediary and regulate this security in a very different way, is that something that could be done, that we could do? Speaking from your former hat as a SEC.
Yeah, I mean, I think the original idea behind crowdfunding was to have a quite different mode available now that the Internet, among other things, makes communication so easy, to raise quite modest sums for entrepreneurial purposes. And what's happened is we've overlain on that original idea the model of a big offering. So you need lawyers and accountants and financial intermediaries, and they all need compliance infrastructures, and you need financials that are in accordance with GAAP. I mean, all these additional requirements, which are the model of a big dollar offering. But it doesn't work if you're raising $40,000 for a company that's going to make cases for iPads.
Mm-hmm. Well, thank you for your testimony. I'll now recognize the ranking member, Mr. Quigley.
Thank you, Mr. Chairman. Mr. Chairman, as to your earlier point about Pabst Blue Ribbon, I want you to know we're in total agreement about purchasing beer I've served here 3 years now. The longer I serve, the more I support purchasing beer. In a letter to the SEC on May 24th of this year, Professor Coffey, the Consumer Federation of America, Consumer Action, and several others wrote the following, and I quote, "We are concerned that the SEC's slow pace on Dodd-Frank, while investing resources in other lower priority initiatives and testifying to its prompt efforts to implement the Jobs Act, creates at least the appearance of bowing to political expediency. We believe that leapfrogging rulemakings whose deadlines are months away ahead of rulemakings whose deadlines are months past, and in some cases cherry-picking which congressional mandates the Commission will even choose to follow, violates both the spirit and the letter of the law and is inconsistent with the SEC's duty to protect investors and facilitate capital formation." Obviously, the question gets to how important it is for Dodd-Frank to be implemented. But in your view as well, is there any reason that the implementation of jobs should be prioritized over the implementation of Dodd-Frank?
I'm not sure I'd call it a priority because Dodd-Frank was passed in 2010 and was 2 years ahead of the line. What I would tell you in the simplest terms is that the biggest problems in our financial economy are the problems associated with systemic risk. We have not yet solved those problems. Issues like the Volcker Rule and how you can keep banks that are too big to fail from taking on risks that could cause them to fail, or the problems with the money market funds, where there could be a bank run on money market funds. Those are huge, difficult problems. They affect not only investors, they affect everyone in the United States because a major failure will push us back into a depression. Therefore, I would say the problems associated with systemic risk deserve a priority. I do agree, however, the problems with small issue offerings, access to capital for smaller companies, are quite important and they should be pursued.
You see no reason to leapfrog one set of priorities over the other in terms of time.
I think one is enormously important. Systemic risk, all of the future of our economy depends upon being able to solve in a credible fashion the problems of major bank failure, and we all are under the shadow of what could happen in Europe within a matter of weeks.
Thank you, Mr. Chairman. I yield back.
I certainly appreciate it. I've got a few final cleanup questions, if the panel doesn't mind and Ranking Member doesn't mind. Professor Coffey, to your comment, I am grateful for you saying this. The SEC prioritized their rulemaking. For instance, they spent enormous resources trying to write a rule on conflict minerals that was in Dodd-Frank. That certainly isn't systemically important, especially in light of the whole world we're going through. Your point is exactly right. I do appreciate that. Now, we also have the general solicitation, the change in relief of the ban on general solicitation contained in the Jobs Act, and they had to write very basic rules. I would foresee, seeing as it's a lifting of something. It's supposed to be done by July 4th. Now, what do you foresee the consequences of them not doing this by the timeline? Mr. Coffey, Mr. Cartwright, this is your stock and trade. We'll start with you, Mr. Coffey. If you'll.
The simplest rules are those associated with private placements. What I would tell you, which I think I have to tell you to add a little reality to this discussion, is that if any entrepreneur advised by any of the great majority of securities lawyers were to consider what is the most feasible option today to raise capital for a small business, they would basically choose between the new liberalized private placement and the new expanded 3B small issue exemption. They are much more attractive and more feasible than a still novel and still very esoteric crowdfunding exemption. And usually,
crowdfunding is still not allowed because we're still waiting for the SEC to write regs by the end of the year. So
even if they write those regs, they have to address so many different things that it's simpler using the very time-honored, established, clear path through private placements with a general solicitation. I think that will be very feasible. I testified in favor of it in December. I still think it will work, and I think those are easy to write.
To take that to the next step, is it because you think that crowdfunding, as was written into law, is too cumbersome, too complicated? too complex?
Remember that the ceiling is low. The amount you can sell any investor is $10,000 if they're fairly wealthy. There are restricted securities, and they come with a negligence-based liability regime. An issuer hears that and says the alternative is a private placement to accredited investors who are numerous, and to sue me, you've got to prove scienter and intent to defraud. I would think most issuers would say, regardless of the SEC rules, I want that way in which I can't get sued and I can sell in unlimited amounts.
Well, you've made Professor Bradford's point on the liability provision within the crowdfunding
But that's Congress,
regime.
not the SEC.
Oh, no. I know. And it's my colleagues, my good friends on the other side of this institution that put in imperfect language that if you read it, you realize that they did not reconcile their differences between paragraphs. The wisdom of the great debating society of the Senate. No offense, this is not a partisan matter, because we can agree the Senate is the true enemy. No division between parties there.
A cul-de-sac, not an enemy.
That's a better point, absolutely. So to your point, that provision, that liability provision, is higher than what you'd have in private placement.
Yes.
Okay. Yes.
It just affects the choice that an issuer will make.
Okay. Well, this is fantastic. We've got a bipartisan, a whole variety of views on this panel, but there's consensus here.
I would add that I agree with my colleague on one other thing, stated slightly differently. There is a rule known as Rule 508 in Regulation D, the private placement rule. It is known to most lawyers as the innocent and immaterial exemption. And it says even if you screw up on a private placement, if your mistake is innocent, immaterial, and it's not intentional, the offering, at least to those people, or at least to most people, will still be good. I think that rule could be generalized for both 3B and crowdfunding as well. And right now, it's totally ambiguous what the standards will be.
Okay. Wow. Thank you. That's amazing. Mr. Cartwright, the ban on general solicitation, this removal, the SEC is supposed to write regs by July 4th. If they fail to do that, what are the consequences to the marketplace?
Yeah, and I will just second much of what was just said. And with respect to general solicitation, as has been said, those rules should be relatively easy to write, so we shouldn't have to wait too long for them, I don't think. And if they're not written, then the existing regime will continue, which is an impediment, makes it harder to raise sufficient funds to reach enough investors. Lots of offerings are completed nonetheless, but presumably at the margins. It's slowing down capital formation, and at this time in our economic history, we could use more. So I think the SEC ought to be urged to promulgate those forthwith.
Mr. Holtuck, you mentioned that you desire to become a crowdfunding portal for equities. So this provision that the Jobs Act opens up, you desire, and your firm desires to do that, to become a portal. So as the law is currently written, how can you compete against broker-dealers given the disadvantages the law imposes on portals? Is that a distinct challenge?
The way the Jobs Act is written right now, we're still at a place where if the SEC is given the education, awareness, and the proper nudging, it could fall out in a way that we can actually become an equity-based platform. That said, there is a risk that if they make it too tight, they add additional requirements, we will not do it. And the reason is we don't think it will serve the issuer or the investor properly. When it comes to making this actually happen and what's our motivation to do so, we believe that you need to be able to offer both perks and equity, and it makes sense for different individuals. One of the things that we haven't really addressed here, and I was hoping to bring up, is the concept surrounding job creation, and what we're actually trying to accomplish here is allowing small businesses who are one of the largest job creators out there to actually access capital in a way that is easier than what a broker-dealer can do. By making it basically transparent and providing clear communication, which is our intent, and we hope the SEC is going to let us do so, is very empowering to individuals right now who are dependent on very costly access forms of capital. Broker-dealers are not the world's cheapest people out there. And if they're licensed, they can charge upfront fees, they can charge back-end fees. And for a small business, the ones who actually create some of the largest job growth numbers out there, they're looking for $30,000, $50,000 sometimes, maybe $100,000, maybe $200,000. A broker-dealer is an extremely expensive way to access capital, and you're putting your faith in another person's hands to guide you throughout that process, and you're not able to get support from your community.
So under Section 304, that undermines a portal's ability to truly act as an intermediary between issuers and investors. And specifically, the Commission prevents portals from offering investment advice and recommendations, soliciting sales and offers, and holding, managing, or possessing investors' funds or securities. And additionally, the Commission or, well, the National Securities Association, presumably, we presume FINRA, may exercise very broad discretion over portals. That seems to me to be disproportionately affecting portals to the benefit of, well, the existing regime or broker-dealers. Is that how you see it?
In part we do, and what we did in order to try to combat that, and a lot of that is education. We produced a white paper ourselves back in May, and the SEC and FINRA both have a copy of it, and we met with both groups as well to discuss it to some extent. The requirements out there and offering investment advice and recommendations and things of that nature is way more strict than some of the Reg D things out there. It's the level of oversight that they're providing here is sometimes excessive, sometimes right. You do have to find the right balance. We're probably leaning more towards the stricter end than the end that might allow looseness.
Stricter or more costly?
They go hand in hand, and it's an issue where, going back to what's the easiest way to access capital, I don't want it to be private placements, because while that is a traditional form of access, it's expensive, and we have to recognize that fact. That should not be your cheapest option when there are other means to do so. Okay.
So, Mr. Coffey, how would you fix the provisions within the crowdfunding title of the Jobs Act so that it could work, it could function, and do so in a costly manner with as minimal amount of fraud as possible?
Now, I do not think the Senate bill is nearly as bad as everyone else seems to think. I have to say the Senate has some.
Well, we're starting with you, trying to wake people up.
But I would say what I was starting to say earlier. Right now, if you were to make one sale to an unqualified person because they didn't get the right disclosure, they didn't get the right investor education materials that Congress has mandated, or they didn't answer questions that proved they understood them, there'd be an issue of whether the whole offering was bad. I think what you need is this innocent and immaterial exemption, which is what we have under private placements, and I think it might as well be applied to 3B as well, so that mistakes that do not have any suggestion that they were intentional and were not widespread should not cost the offering.
Must that be done legislatively?
No.
Or can the Commission act?
508 is not based on legislation, of Regulation D. The SEC can do in one context what it's done in others. Well,
we're hopeful that the SEC is either watching this, and if so, hello.
I'll get angry emails if they are.
And if not, we'd hope they'd read the transcripts. And if not, we have Chairman Shapiro in on Thursday morning, and I'll read her the transcript. It should be for a very entertaining and maybe lengthy hearing. But, Mr. Cartwright, same question. How would you improve this crowdfunding section of the Jobs Act so that this offering, these low-dollar offerings, can actually occur in an affordable fashion?
Well, I think the simplest way to say that in very general terms is to move it back in the direction of the bill that came out of the House. What we've done is overlaid the model for big offerings with lots of intermediaries and gatekeepers who are very expensive on an original idea that was designed for small dollar offerings by entrepreneurs for small scale businesses with a very different model, and they really are incompatible. So there's probably lots of places where you could move things back in the direction of the original idea that would be helpful, and you probably need to do a number of those before you get to the point where there's been enough change to make this approach viable. I think that as it's currently written, it may well have been strangled in its crib, just because there's been so much added to it that it will be, at least for the lower end of the range, the $100,000, $200,000 end of the range, the costs will be prohibitive. And I suggested in my written testimony that when the SEC does do rulemaking, it ought to carefully evaluate what those costs will be. And if in the SEC's judgment, after rigorous cost analysis, it turns out that all of that layering is going to consume the proceeds and more, then the SEC ought to say that in their release so that Congress can then be aware and take whatever action Congress feels is appropriate under that circumstance.
Mr. Holthock, same question.
I saw the original bill, and personally, naturally, I favored that one a lot. Of course, I understand that intervention was necessary in order to get it passed, and it did so with bipartisan support. It's a tough one for us because we come from experience, having done this for several years already, and we understand how people behave and what the cost structures are. Going back to the example mentioned to you before, that $500 raise came at a cost to that individual of only $20. That's not expensive. It simply isn't. We do a lot now already on the back end that you don't even get with current Reg D exemption work. I am able to check an individual with OFAC, for example, that is simply not done otherwise. I'm able to track funds and how they're moved, how they're handled, how they're spent, whether there's fulfillment, what's the performance. The oversight I'm able to perform with a web-based platform is so much more significant than the paper-based trail from the 1930s, which we're still using. It's mind-boggling to me that we're not adopting the modern perspectives. And naturally, if the SEC is listening, I would love to explain to them how crowdfunding works. We've tried in the past and we've had some opportunities, but one of the issues right now is there's a big difference in education. When people don't grasp something, they tend to move back to the older roots of understanding, and layering the investment banking fold over this thing is not going to work. We're at a different era right now, and we need to be able to strive forward and drive innovation. When other countries are already effectively implementing equity crowdfunding, we're one of the last developed nations out there not doing so. And you know, that for me is personally very troubling, considering we have a huge opportunity here and entrepreneurship really was born in this country.
Professor Bradford, same question, final word.
It's hard to answer that question quickly because I've written a 60-page article basically talking about the problems with the Act and what I would change.
Yeah, I've got it right here.
I assumed you did.
It is, and for those of you who are watching or listening to this, Professor Bradford has, in essence, written the Bible on crowdfunding, and something that my whole staff has read and I've read as well. So, but for the record, if you could
absolutely
outline those items.
If I could boil it down to two things. Number one, something we really haven't talked about a lot here today. The first thing I would do is clear up the ambiguities and the drafting errors in the bill. There are a lot of problems. There are a lot of things that are unclear in exactly what the meaning of the language is. There are some inconsistencies that need to be cleaned up, even if we don't change any of the regulation. And then second, to echo what many people have said today, I would just generally reduce the regulatory burden, particularly for the small. If I had to limit it, I'd say particularly for the smaller offerings. The burden the exemption is simply too expensive.
So the ambiguity you're mentioning, one of which, as I recall, is the distinction between how much you make and how much you're worth, your net worth versus your income. And in the drafting, it doesn't distinguish between either, nor does it give any indication which one should be the one you look to if somebody's net worth is under the amount that they make, or their net worth is over the amount that they make.
Yeah, the exemption creates three categories of individual investment limits, and the middle category, where somebody's annual income or net worth is over $100,000 and the other of those two figures is below $100,000, both limits apply to that middle category, and obviously you can't have two limits applying to one investor. And then there's also, for higher-end investors, it's unclear whether it's the greater of 10% of their annual income or and net worth, or the lesser of those two numbers.
Interesting. Well, you know, the ambiguities need to be resolved. Obviously, there is some consensus in terms of what is material as opposed to incidental errors or omissions in this offering. And I think we've had a very informative panel today. Mr. Quigley, do you have any final?
Thank you.
Okay. Thank you. And I want to thank the panel. I thank you for the opportunity to ask questions of you. You've been very generous with your time and very instructive in terms of your words and your explanation. I thank you. We hope that this furthers the cause of helping small businesses, especially, get the capital they need to grow or to survive. And we certainly appreciate your willingness to engage in this exchange. Thank you for your time. This hearing is now adjourned.